Bakhtier Shakhnazarov against Porter Airlines. The Human Rights Commission, on its recommendation, deliberately omitted many very important facts and details, misinterpreted or ignored my evidence I mentioned in my submissions, emails, and phone conversations. From the very beginning, the Human Rights Commission should have asked me if I was unionized or not. Porter Airlines plotted with Port Toronto to orchestrate a fake notice of infraction against me. I can prove everything with the documents. But other Caucasians who did the same as me weren't even disciplined. Only in 2019, I realized that the discipline and suspension from 2017 constituted a human rights violation. The Human Rights Commission excluded Port Toronto from my complaint without July informing me. The Human Rights Commission erred again, alleging that I haven't provided a reasonable explanation for the delay in contacting the Commission. Even after that, the respondent didn't initiate any conversation or meeting about my complaint. I got confused. However, the manager asked me to redo all training. I realized that the respondent's submission about quickly reacting to any allegations of human rights violations was a farce. In its recommendation, the Human Rights Commission deliberately didn't evaluate the request I filed with the union asking to file a grievance and to what happened further. Moreover, the Commission omitted many related facts and misrepresented others. Looks like the Commission was very busy to respond to my urgent email. I received the response 2 months later. Can you imagine? I immediately emailed the 3 union members at Porter Airlines asking them to file a grievance. In order to move forward, are you in agreement to have the decision shared with Porter? The respondent openly lied about not receiving the Commission's decision, but the union has never filed a grievance and breached the collective agreement. Hi, Bakhtier. Yes, I received the email. I'm not sure if it will be the local or the national responding, but we will copy you nonetheless. Even after reading the Human Rights Commission's email, people from the Unifor Local 2002 didn't know what to do with my request to file a grievance. Can you imagine that? It was illegal doing so, as the collective agreement has no article about transferring the grievances to the national union. I don't know the reason why the union is not filing a grievance. However, the recommendation doesn't say anything about this important fact. I said that asking the union to file a grievance meant sending the sheep to the wolf. More than 2 months has passed ever since, but the union didn't even file a grievance. But Porter Airlines asserts that it didn't even receive human rights decision dated July 28, 2021. My employer kept harassing and discriminating me, not showing any empathy when I was sick, when I informed them about attending an emergency room in the hospital. I expect that a respondent would initiate a meeting with me, but a respondent did nothing. I received the response 2 months later on December 13, 2021. Can you imagine? What a response, quick response, right? This is in response to an email dated October 15, 2021. I can confirm that the respondent was indeed sent a copy of the letter of decision sent on July 28, 2021. The part of the collective agreement titled Complaint Resolution Discrimination or Harassment says, C. The company and the union will review the complaint and, where warranted, a joint investigation will be conducted. D. It is the intention of the union and the company that, where practical, a joint investigation will begin within 5 calendar days of the lodging of the written complaint and shall be completed within 15 calendar days after the lodging of the investigation. H. Nothing herein shall prevent an employee from seeking redress under the Canadian Human Rights Act with respect to complaints of discrimination and harassment. After the respondent fired me on March 3, 2022, I asked the union to file a grievance. My email above should have been more than clear to the human rights officer who prepared the recommendation. A hearing needed to be scheduled after that, but the commission treated me differently, not willing to understand my case and not evaluating the facts and reasons I wrote to explain the delay in filing my complaint. In fact, the commission impeded my case too. It made me nervous and angry that Mrs. Roy didn't care checking my previous explanations to get a full response to her inquiries. In its submission, respondent wrote that, I'm quoting, Porter takes great exception to the allegations of discrimination. It was my understanding that going to the court would be the next step after the management denied the grievance. In October 2017, Ashley Watkins responded to my email where I asked about the outcome of the grievance. He wrote that my case was closed and the union wasn't obliged to let me know about the outcome as it was the union's grievance, not mine. That hiring a lawyer for further steps to take the matter to the court would be costly. The Human Rights Commission confused and mixed up two completely different issues with the uniform and later with the national union. Where will you go to file a complaint if the judge rapes your mother? Who is deceiving me? The respondent, the union, or the Human Rights Commission? It seems to me that those three entities are fighting against me together. The only question here is, why is the Human Rights Commission not understanding my English? If you were patient enough and listened to my submission until the very end, you may realize that even Human Rights Commission of Canada may be prejudiced towards visible minorities like me.